Friends, welcome to another video in our series Finance and Investing Tidbits. The theme of this video is why do banks insist on personal guarantees of promoters when they give large loans to companies? Welcome to this video. You would perhaps be aware about this concept of limited liability, but maybe at the cost of repetition, I would just like to share a little bit about that. When you observe the name of any company, you will find the word limited appearing at the end. What is the limit that we are trying to set? This is not limit on expansion. This is not limit on how much capital it can raise. This is not a limit on how much property it can invest in. This limit is on the liability of the individual shareholders. Now, why this is important? Companies are created on the theme of separation of ownership and management. People who are at the helm of the company's affairs or even its managers need not be shareholders, and naturally every shareholder is not a part of the management. So when these two are separate, the people who are the shareholders are naturally not party to many decisions which are taken by the company. In that case, they need to have a protection of limited liability, which ensures that even if something wrong happens with the company or the company is not able to repay the debt and the banks take certain actions, the personal property of the people who have invested should not be affected. That is really the theme of limited liability. And that has helped in creation of large corporations, because it's only because of limited liability idea that investors are willing to put in their hard-earned savings. Who would like to invite more loans on one's head than one has already taken at a personal level because of investment in some shares? Because of limited liability protection, whatever happens to the company's ability or inability to repay the loans, no one can come to the investor's doorstep and recover any share of that loan. Now, this is very important for non-promoter shareholders, the lay public who have become shareholders, or even institutions who have become shareholders and who are not really involved in the management. It is this protection which propels them to invest the money. If they don't have that protection, and if they have the fear of unlimited liability, nobody is going to come forward and invest. Now, company law applies to every shareholder equally. So just like the lay shareholders, the public, the outsiders get this protection, the promoters also get the protection of limited liability. But the fact remains that it is the promoters who drive the board decisions. The Asian model of business is that the promoters are quite hands-on with the business. In the Western world, people who have created companies, their next generations, quite often hand over the management to professionals and kind of stay back. But in India and many other Asian countries, or most other Asian countries, the promoters continue to sit on the board. They actually are at the helm of the affairs and drive the board decisions. And unless those resolutions or decisions are outrageous, usually the independent directors, the non-promoter directors also support those resolutions or the board decisions, and those decisions are carried by a majority or even unanimity in the board meeting. Quite often, there are some decisions about expansion, acquisitions, which are quite often taken out of ego. So becoming big is often an ego-driven decision, and this is where the promoters can make some judgmental errors. Now, when a lender like a bank is giving a large loan, it poses a lot of risk to the lender. And naturally, the lenders get perturbed by the protection offered by the Companies Act to the promoters being shareholders, and therefore to protect their own interests, they take certain steps, apart from, of course, mortgaging or hypothecating property. So one of the things that they do is, so that the promoters don't take shelter under the concept of limited liability, is that they ask for personal guarantees from the promoters. So while the promoters enjoy limited liability protection under the Companies Act, the banks override that protection by taking personal guarantees, and that obviously creates a lot more responsibility on the promoters when they take decisions. It does not mean that still they may not take outrageous decisions. They may, but at least that incentive to do so becomes harder because their own personal property is at risk. Friends, if you like this video, feel free to share it with your friends. Thank you so much.